Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. When we talk about divorces, the general thing that comes to mind is, a traditional situation where people don't get along, they get divorced, maybe they have kids, maybe they don't. It's a very unique situation when the divorce involves custody and the considerations of a special needs child. As one may know, either from personal experience or from just general education in the public, there are oftentimes when if someone has a special needs child, there are special expenses associated with that. It could be all sorts of things. It could be educational expenses. It could be ABA therapy that's not covered by insurance. It could be accommodations that are structural in the house. There are expenses. And so when you get a divorce, then all of a sudden, let's say there are structural accommodations in the house and ramps and whatnot. Let's say there are those things, and now we're going to sell the house. Now we got to get two different houses, and we have to allow for that. Do both parents split the cost of that? Well, this is a very common issue. I mean, you're supposed to have a situation where the child can now be accommodated in two households because we're getting a divorce, right? So now, theoretically, we might have double that expense. Who pays for it? In a situation where the parties, let's say, make the same amount of money, it's a little easier to figure out. Parties make the same amount of money, so they both have the same amount to live off of, which means they're both equally responsible and or capable of absorbing that expense. It may be something that they can easily absorb on a scale of difficulty of 1 to 10. It may be a 1 for both parties. It could be a 7 or an 8 for both parties and be pretty difficult. But they're both, because they make the same amount of money, they're both going to have the same issue. So in that sense, it's equitable. However, if there's a situation where one party makes significantly more than the other, then we're in a situation where one party can best afford that. So how does the court handle that? Well, there are different ways to do it. The court might outright say, okay, these are the expenses. There's $5,000 extra that's going to be needed because we need a ramp or we need this or we need that, and therefore you are going to pay it to you. $5,000, you're going to absorb the cost of building that structure. Why? Because you are better able to do so. You have the better job. This person is more of a homemaker. You've been in the workforce, those kind of things. Another thing the court can do, another option, is that the court can say, look, you're going to have more expense, you're going to have more expense, but you're better able to afford the expense because there's a huge disparity of income between what person A makes and what person B makes, and therefore the court will order alimony. The court will order spousal support designed to sort of pick up the slack of the extra expenses. Sometimes the extra expenses are personal expenses. Sometimes the extra expenses of alimony might involve a different kind of handicapped accessible structure, etc. So it could find its way to that. It won't likely impact child support as such for the amount, because child support is based on a formula of how much dad makes and how much mom makes and how many overnights. So it's not going to affect the formula as such, although in certain situations it could theoretically lengthen the duration of child support, especially depending on which jurisdiction you're in. But if you have any questions about that with respect to your particular case, of course, reach out and we'll be glad to help you out.